Welcome, everyone, and thank you for being here for the launch of model legislation to help state lawmakers and advocates across the country introduce and enact state voting rights acts. My name is Dimitri McCain, and I serve as the Director of Policy at the Legal Defense Fund, or LDF as we call it. Listen, for more than 85 years since our founding in 1940 by Thurgood Marshall, LDF has worked to protect and expand voting rights for Black people across America. What started out as a fight primarily about Black communities in the South is now a fight to ensure that all voters can participate effectively and in a truly inclusive multiracial democracy. So, LDF is thrilled to be co-hosting today's event with the Asian American Legal Defense and Educational Fund, LatinoJustice, PRLDEF, and Campaign Legal Center. And we are also thrilled to have partnered on the drafting of the model legislation that we will be discussing today with these groups, as well as the Election Law Clinic at Harvard Law School. So, folks, listen. We are convening today at a fraught and dangerous time for our democracy. Not since LDF's founding in the Jim Crow era have we seen such sustained attacks on the right to vote. And this time, the White House, the Department of Justice, and the courts are the sources of threat and not necessarily hope for recovery. The largest looming threat comes from Louisiana versus Calais, a Supreme Court case LDF's very own president and Director-Counsel Janai Nelson argued just this past October. It's a case that could impact voting across the entire country and a case that could be decided any day now. Calais is the latest push by states to erode the Voting Rights Act and to specifically upend how voters prove or fix racial discrimination related to election methods and district maps, known as racial vote dilution. This case will determine what voting rights will look like in America for decades. And the best way for states to step up and protect their own voters in the face of all these threats is to enact their very own state voting rights acts. And these laws take the best parts of the federal VRA, strengthen and streamline them, adapt them to local needs, and codify them at the state level. LDF and our partners, we've been leading a movement to enact strong state VRAs for several years in close partnership with state-based organizations and other grassroots partners who actually are the ones who know what works best in their communities. Now, I know our expert presenters will walk through the landscape of state VRAs, but I'll just say what we seem to have hit on right now is an inflection point where interest has grown tremendously over the last few years, including in the South, where the need is actually the greatest. And as a Texan, I am thrilled to see my home state introduce the Barbara Jordan Voting Rights Act of Texas just last year. So kudos to those state partners who helped make that happen. But because of the explosion in interest, this model legislation actually comes at a very perfect time. Even before its formal release today, the model legislation heavily informed many of the new state VRA legislations that we've seen introduced just this past year. I say informed because this model is not intended to be just a one-size-fits-all approach. Rather, it's a model that must be adapted to local conditions. And the annotated draft released today provides guidance on just how to do that. So with the current annotated draft available for legislators and advocates from which to build, we aim to supercharge our recent momentum. At today's event, we'll first hear from our keynote speaker, New York State Senator Zellnor Myrie. We'll then hear remarks from the heads of the 4 co-hosting organizations. Now, folks, Each of the organizational leaders speaking today is an amazing racial justice and pro-democracy leader. And it would just take me way too long to introduce them individually. So I'll refer you to our event registration page where you can actually read their bios yourselves. So after remarks from the co-hosting organizations, we'll then shift over to a brief presentation on the state VRA landscape and the model bill from our very expert co-authors. And there you will learn exactly how to access the model legislation and related resources. And then we'll close out with Q&A from you, the audience. Now, I know you might be itching to look at the model legislation now, but I ask you to just hold tight as we move through our informative program. And so now, I am actually honored and excited to introduce our event's keynote speaker, New York State Senator and Brooklyn native, shout out to the Brooklyn folks, Zellnor Myrie, who has represented Central Brooklyn in the 20th Senate District since 2019. Now, since joining the legislature in New York, he's won significant victories on affordable housing, near and dear to me, criminal justice, and gun safety. And as chair of the Elections Committee, Senator Myrie has pushed New York forward with reforms such as early voting. And most relevant today, he was the lead Senate author of the John R. Lewis Voting Rights Act of New York, also known as the New York Voting Rights Act, or NYVRA as some call it. Now, the NYVRA took state VRAs actually to the next level by bringing together a comprehensive set of protections against discrimination, including the nation's very first state-level pre-clearance program. We know how important that is. So we're super grateful that Senator Myrie for his leadership in New York, and we are thrilled that he's actually here today with us to help us launch our model legislation. Senator Myrie, the floor is yours.
Thank you so much, Demetria, for such a warm welcome. And speaking of warmth, no matter where you are in the country, I hope you are staying warm and folks being prepared for what is to come this weekend. But as you heard, I'm State Senator Zellnor Myrie. I proudly represent the 20th Senate District in Central Brooklyn. But for today's purposes, I was the Senate sponsor for the New York Voting Rights Act and was joined by my colleague in the Assembly, Latrice Walker, to get that across the finish line. I am so excited to be here today with all of the amazing organizations 3.5 years after we made history together, enacting the most comprehensive state voting rights act in the nation back in 2022, and setting a new standard for protecting voting rights at the state level. I'm passionate about voting rights. As you heard, I was the chair of the Elections Committee for my first 6 years in the state Senate. And I very, very quickly learned that, as many of you on this call know, if we do not have the right to vote, then all of the other rights are at risk. And I was proud to sponsor on my very first day on the job in the legislature early voting, along with a host of other reforms. But the crown jewel of what we were able to achieve as I chaired the Elections Committee was the New York Voting Rights Act. And I decided to champion this bill because I knew and saw that discrimination was not just a Southern problem. It wasn't just a red state problem. It occurs whenever and wherever entrenched power structure fears sharing power, fears diverse and inclusive multiracial democracy. And that is what we should be striving to become as states and as a nation. I saw that a lot of the discrimination happens at the local level. I know it is incredibly sexy and attention grabbing to focus on the federal stuff, but a lot of the more insidious practices were happening in localities all across my state. And so as much as I love New York, I know that we were not the first to pass a Voting Rights Act. We were beat by California, Washington, and Oregon, Virginia, and they went before. But we were the first, as Demetria referenced, to pass a powerful protection against voter discrimination in the form of a state-level pre-clearance. This is, of course, as a result of that being eviscerated in the federal VRA many years ago. We also did something special in putting together a package of comprehensive set of protections that would allow for us to deepen the protection we had for the franchise. Now, the bill was passed in 2020, signed into law in 2022. I'm really excited to report that it is already working. Our illustrious Attorney General, someone you may have heard of by the name of James, implemented our pre-clearance system back in 2024, and multiple actions have already been filed to protect Black New Yorkers from having their voices weakened or drowned out by discriminatory at-large elections or district maps, including a historical settlement in Nassau County. I know we got some Nassau folks on the call now. And also seeing elected officials of color being elected for the first time in the jurisdiction's history. It's been amazing to watch. 17 counties, 7 cities, 6 towns, 6 school districts, 1 village, all covered under pre-clearance here in New York, and it is actively working. Now, you also heard this and you know this, that's why you're on this call, that state voting rights acts are more now than ever. What we're seeing on the federal level is incredibly frightening. We're all waiting for a Supreme Court decision that's going to come any day now that undercut the VRA's protection against discriminatory district maps. We have lower courts that are saying that voters can't use the VRA directly to defend themselves, but that they have to rely on the DOJ. And of course, the DOJ itself has now been weaponized against voters rather than acting to defend them. This model legislation being rolled out today will empower legislators and advocates across the country to do what we've done here in New York. It's timely, it's thorough, it captures lessons learned from our work in New York, as well as the other states that have followed, like Connecticut and Minnesota and Colorado. I want to again thank all of the co-authoring organizations and all of you for being here today and joining the growing movement to enlist states to do what the federal government will not: protect Americans against discrimination in voting. Now I am very excited to turn the mic over to Janai Nelson, President and Director-Counsel of the Legal Defense Fund. Janai is a former law professor and a voting rights litigator who this past October, and let me just take a point of privilege here, I was listening to this argument with my wife, who was not a lawyer. And my wife turned to me as she heard the argument, and she said, "Babe, that lawyer is good." And I said, "We know exactly who that is, and that is who we are going to hear from now." We want to thank Janai for being such a visionary champion of the State Voting Rights Acts, personally helped make the New York Voting Rights Act a reality. Thank you for being such an ally. And Janai, the floor is yours.
Oh, thank you so much, Senator Myrie, for that introduction and for those kind words. Thank your wife as well. I am a proud constituent in your district and just grateful for your partnership. So let me say good afternoon to everyone. And yes, I'm Janai Nelson, President and Director-Counsel of the Legal Defense Fund, or LDF. For those who don't know, LDF is the first law organization in the country whose mission is to advance racial justice. And for over 85 years, since we were founded in 1940 by Thurgood Marshall, we have been fighting to protect and expand voting rights as part of that mission. And it is such a pleasure to be with you for the presentation of the inaugural Model State Voting Rights Act. This powerful legislation offers a blueprint for safeguarding and strengthening access to the ballot for voters and other voters of color, and quite frankly, for safeguarding and strengthening our democracy for everyone. I know this entire process has been a labor of love, emphasis on labor, for the multiracial, multidisciplinary, cross-sectional coalition that it took to get it in place. And I want to thank each and every person at the lead organizations that played a role in perfecting this blueprint for inclusive democracy. And those organizations are the Asian American Legal Defense and Educational Fund, the Campaign Legal Center, the Election Law Clinic at Harvard Law School, and LatinoJustice. And of course, my colleagues at LDF. Adam Leaz, Michael Pernick, Imani Brooks, Demetria McCain, who you heard from, and Duell Ross, who argued the Allen versus Milligan case that won before the Supreme Court just a few years ago. These are all staunch voting rights advocates who exemplify the power of combining our policy and litigation expertise to produce a legislative template that is deeply informed by our long history of work to help pass the Voting Rights Act of 1965 and our decades of experience enforcing voting rights in the courts. I also just want to return to Senator Myrie and thank him for having the courage and foresight to sponsor the John R. Lewis Voting Rights Act of New York, which he explained to you. It set a new standard for protecting voters at the state level against discrimination in all its forms. You are truly a champion and the one that we needed to make history and to build on right now in this moment where our entire nation is facing a crisis of democracy. So, in every election, in districts and neighborhoods across the country, voters have to overcome barriers in order to cast a ballot. And that should never be. Whether it's a lack of accessible entrances, whether it's language assistant issues or discriminatory redistricting designed to silence voices of color, voting in this country is not easy. As we all know, the robust Federal Voting Rights Act of 1965 is now a shredded shield as a result of Supreme Court and lower court decisions that have severely circumscribed its reach. And with federal attacks on voting rights increasing every day, we have to use every tool at our disposal to ensure voters are protected, to ensure representation is fair, and that ballots are accessible. State voting rights acts are one of the most powerful tools we have to counter the increasing and inventive incursions that we are facing. State VRAs don't just restore safeguards that the federal courts have limited, they allow states to be laboratories of democracy and to go even further by raising the floor of baseline protections against racial discrimination and partisan manipulation. And state voting rights acts are extremely popular. Nearly 8 in 10 voters support passing a state VRA where they live, and they are already a reality in 8 states and counting. And that's where you all come in. So thanks to this model bill, other states now have the opportunity, and residents of those states can join the fight to become champions of democracy where they live. We know that we can't be everywhere to drive advocacy ourselves, which is why I encouraged our team to develop this adaptable model legislation that grassroots organizations and everyday citizens can mobilize to get passed in their state. So I am thrilled that we've partnered with these other extraordinary organizations to advance this exciting new law at a time when things feel so dismal and so daunting. We have the power to use model legislation to example what it means to be a functioning, inclusive, multiracial democracy. So thank you for joining us. Please sign up to be a voting rights champion in your state. And I will now pass it to my colleague and partner, Bethany Lee, Executive Director of the Asian American Legal Defense Fund. Thank you for being with us.
Thanks, Janai. Thank you for your leadership and your continued partnership. I'm so proud to be here today. I'm the Executive Director of AALDEF, the Asian American Legal Defense and Education Fund, one of the oldest national Asian American civil rights organizations. We are based in New York, and I appreciate partnering with all of you to uplift this important state-level voting rights work to advance the ways that we build power in our communities. AALDEF has been committed to the State VRA Model Project from its inception, and to the larger project of state-level voting rights reforms to move our country towards a multiracial democracy. The power and opportunity of this model legislation is immediately apparent in so many different states across the country as we engage with communities, reduce barriers to accessing the levers of democratic power, and transform the status quo of who our democracy works for. New York State, as you all have heard here today, has been a nationwide leader in this endeavor. In New York, we successfully passed the New York Voting Rights Act and now fight alongside all of our partners here to defend and advance its value in the courts. We established the first Asian influence district through state VRA litigation, and we're developing more tools to identify where communities of color that may not make up a majority can still influence elections. State VRAs, like New York's, enhance our community's voices, and the impact of our work together has already proved historic. We all know the challenges on the federal level have never been more real, but we are not backing down, and this state level work is a critical component as we continue to find more ways to advance our community's rights. If we're all serious about all voices being represented, a state voting rights act is a powerful protection and advancement that every state should introduce and pass. State voting rights acts provide a map not only of the advancements we've made, but importantly of where we still must go. We conduct voting registration work each week at naturalization ceremonies, and as a result, we have the privilege at AALDEF of witnessing hundreds of new people gain the right to vote and cement their voice in this country. So we're ready and proud to continue working with you all to ensure those voices, especially those most vulnerable, are heard. Thank you so much for your work together, and I'll pass the mic to our partner at LatinoJustice, Lourdes Rosado.
Thanks so much, Bethany. It's always great to see you, and so much work we've done together and continue to do together is so important to me and to Latino justice. So again, I'm Lourdes Rosado, and I have the privilege of serving as President and General Counsel of LatinoJustice PRLDEF. And we're a civil rights organization with more than 50 years of experience of doing fierce advocacy on behalf of the Latinx community. We are really proud of our role in drafting this model state voting rights act, which we did in partnership with LDF, AALDEF, the Campaign Legal Center, and the Election Law Clinic at Harvard Law School. This model bill really serves as a beacon of opportunity and hope for the voting rights movement. And that movement has experienced some major setbacks because of actions of this federal administration, as well as the Supreme Court's gutting of the Federal Voting Rights Act. Given this federal landscape, it is absolutely time for the states to collectively pass and implement robust voter protections that will support minority and actively suppressed communities. Now, we're also really proud of the language access component to this model bill. This component, or part of the Model State Voting Rights Act, introduces an innovative tiered threshold system that allows for multiple languages to be accommodated based on varying populations. And those languages are accommodated through multilingual ballots, signage, interpretation, and more. At a time when forces are really actively oppressing and repressing our immigrant communities, it's critical that we continue to robustly guarantee the right to vote for all eligible voters, especially those who speak a language other than English. Democracy is for the many, not the few, and LatinoJustice PRLDEF will not stop advocating until all eligible voters can meaningfully access the ballot and have their votes counted. And now I'm turning it over to our colleague, Bruce Spiva, who is Senior Vice President of the Campaign Legal Center.
Thank you so much, Lourdes, and thanks to everyone for joining us for this important discussion. My name is Bruce Spiva, and I'm the Senior Vice President at Campaign Legal Center. State VRAs are among the most powerful tools we have today to confront discrimination in voting and to ensure that all Americans can participate in our democracy. At Campaign Legal Center, we're proud to have supported the enactment or strengthening of state VRAs in several states in Washington, Oregon, Virginia, New York, Connecticut, Minnesota, and Colorado, and to stand alongside advocates working to pass them in several more states, such as Michigan, New Jersey, and Maryland. CLC has also brought the first ever lawsuit under the Washington State Voting Rights Act in Yakima County, Washington, and under the Virginia Voting Rights Act in my hometown of Virginia Beach, Virginia. In the Washington VRA case, our plaintiffs won a historic settlement that for the first time allows Latinos, people of color, and immigrants in Yakima County to have an equal opportunity to elect candidates who are responsive to their needs and priorities. That case and others demonstrates how state VRAs are already being used to make significant strides in protecting the freedom to vote for historically disenfranchised communities at the state and local level. And that's where so many decisions that shape our daily life are made. These state-level protections are particularly necessary in light of the federal attacks on voting rights and the significant gap left by the weakening of the Federal Voting Rights Act. Since 2018, there has been a renewed effort to pass state VRAs, and the momentum behind these important tools has only grown. That's why CLC is incredibly proud to have joined our partners in this effort to develop a model state VRA. With this model, states can lead the way toward a more inclusive and accountable government that is truly of, by, and for the people it was created to serve. Finally, thank you to Senator Myrie for being a tireless champion of the New York Voting Rights Act, and to all of our partners for your dedication, leadership, and collaboration. I will now pass it on to Adam Leoz to give a more in-depth presentation of the model bill. Thank you.
Thanks so much, Bruce. I really appreciate it. As the slides come up, we're going to walk through a short presentation on our model bill featuring many of the expert co-authors. So next slide, please. As you can see on the slide coming up right now, we're going to talk about state voting rights acts generally and where they're moving. Then we'll dig into the model legislation itself, laying out the core components and highlighting just a few key ones. And we'll talk about how you can get more involved in the work to enact state voting rights acts and exactly how you can access the model legislation. And we'll close out with some audience Q&A. Next slide, please. I want to first note that when we talk about state voting rights acts, we're specifically referring to legislation that provides officials and voters with tools to fight and prevent discrimination, racial discrimination in voting. And those laws, as Demetria said on top, basically take the best parts of the Federal Voting Rights Act, strengthen and streamline them, codify them into state law, and often provide complementary provisions around. Now, this is different and distinct from laws or rules that set the procedures for how we administer elections, like voter registration rules, early voting, etc. These are both critical, and legislation in some states mixes the two together. But for our purposes today, we'll be focused on protections against discrimination. Next slide. So let's talk at the outset about why state VRAs matter so much at this moment and why these anti-discrimination protections are critical. As we heard from many of our speakers up top, the short answer is that we're experiencing the most sustained attack on voting rights since the Jim Crow era. After the 2020 election and record participation by communities of color, we saw a backlash and waves of states enacting voter suppression laws. And now we're seeing attacks at the federal level through executive order, through a weaponized Department of Justice, and through hostile legislation in Congress. And over the past 15 years, the federal courts, with some notable exceptions like the Milligan case that we've talked about, have largely reversed course on a proud history of enforcing voting rights. The Supreme Court, as we've heard, gutted the heart of the Federal Voting Rights Act in the Shelby County case, which was the pre-clearance protection, and then chipped away at the VRA's voter suppression protections in 2021. The Louisiana versus Calais case that we've talked about and maybe decided any day now is the latest effort to undercut the VRA and specifically to roll back protections against racial vote dilution, which happens when election methods or district maps weaken or drown out the voices of voters of color. And of course, this comes just 3 years after the Supreme Court essentially sustained those same protections in that landmark Milligan case. In the face of these threats, states must step up to the mantle to protect their own voters from discrimination. And state voting rights acts are a powerful, practical, and popular way to do just that. And let me give you just one example. In late 2023, a panel on the Eighth Circuit Court of Appeals first ruled that voters cannot use the Federal Voting Rights Act directly to protect themselves from discrimination, but rather must depend upon the Department of Justice. The ruling was eventually upheld by the full Eighth Circuit, that same concept, But Minnesota democracy leaders acted quickly and enacted a Minnesota Voting Rights Act in 2024. So now, voters in at least one Eighth Circuit state can use a similar provision to directly bring actions to protect themselves from voting discrimination and racial vote dilution and voter suppression at the local level. Next slide, please. As folks have mentioned, the urgent threats that we're seeing have spurred substantial momentum for state voting rights acts. 8 states currently have their own VRAs. California was the first to go in 2002, and now a state voting rights act has been enacted every single year since 2018, except for the pandemic year of 2020. And these laws have generally been getting stronger and more comprehensive, including, as Senator Myrie displayed, the first ever pre-clearance program in New York. And you can see a robust list of states that also have introduced legislation, including places like Maryland, Michigan, and New Jersey that have made substantial progress towards enacting these laws. And we expect this list to grow substantially in 2026. Already on Martin Luther King Day, leaders in Mississippi and Vermont announced the introduction of their own state voting rights acts, and we're working with allies in several other states to promote introduction in 2026, with many of these laws informed by the model legislation that we are talking about today, many of these pieces of legislation. Next slide, please. One last point that I'll emphasize is that state voting rights acts are not only provide powerful protections against voting discrimination and are a practical way to push back directly on the current attacks on voting rights, but they're also very popular with the public. You can see here that more than 3/4 of voters support enacting a state voting rights act in their own state, including more than 60% who support that strongly. And this strong support largely transcends partisan and demographic lines. Next, please. Even more significant to me, about 3/4 of voters actually want their own state representatives to prioritize enacting a state VRA in their state. And you can find a lot more detail on this polling on our state VRA toolkit and landing page. So to summarize, state voting rights acts are a powerful, practical, and popular tool to protect Black voters and other voters of color from racial discrimination in voting, and are needed now more than ever. And with that, I'm happy to pass the mic over to Patrick from AALDEF.
Thank you, Adam. I'm Patrick Stegemeller, voting rights attorney at the Asian American Legal Defense and Education Fund. And as Adam laid out, this moment calls for comprehensive, concentrated action and a national strategy that can meet the realities facing local communities. That's why we're here. So that's why a model state VRA, because this model bill is a tool that this moment needs. Building on the momentum and lessons learned from states that have passed or attempted to pass state voting rights acts, the model bill is a culmination of experience generated across the voting rights advocacy landscape, and it offers a way forward for progressive state-level action that provides collective solutions to the challenges that communities and advocates have and will continue to have in fighting for the right to vote. By consolidating the gold standard of State Voting Rights Act language all into one model bill, we build a consistent baseline across states for advocates to show their lawmakers that better is not only possible, it's required. And the model bill's provisions, which over the past year have been constructed and vetted by community groups, legal experts, and lawmakers, come ready to be introduced. Basically tomorrow, if you wanted to, and we hope that you want to, which significantly increases the efficiency of the drafting process. I'm sure we all know how turbulent the state legislative process can be. So having a resource ready to put in the hand of a representative, a bill virtually ready for introduction that has tailoring built into it so that it's responsive to the needs and realities of that particular state, can be tremendously helpful. And crucially, by bringing together the experience and enthusiasm of advocates in states who have passed state VRAs, in states who may soon pass them, and in states where the introduction of the bill can be an important power building tool, we increase the shared power of this movement by demonstrating that we are organized, that we know what is needed to meet this moment, and that we are in this fight together. And with that, I will pass the mic to my colleague, Lotta Knott from the Campaign Legal Center, who will expertly walk us through exactly what the model bill is made of. Lotta?
Thanks, Patrick. And yes, now that you know why we drafted a model bill, we're going to delve into some of its specific provisions. Can we go to the next slide, please? Thank you. The model state VRA is a template that state lawmakers and advocates can easily adapt to safeguard voting rights and prevent discrimination voting in their own states. All of the organizations that collaborated in drafting this model bill, collectively, we have extensive experience with drafting and advocating for state VRAs in multiple states and litigating cases under the federal VRA and existing state VRAs. So we brought to this project all of our knowledge on how to make this in terms of protecting the rights of voters. And the provisions of this model bill are grounded in best practices that have been developed in other states like New York, Minnesota, Colorado, but they're also flexible. So it's all a bill. This is a model that's meant to be tailored to each state's unique laws, demographics, and racial history. Now, the model state VRA has 8 core provisions, which are listed on this slide. State lawmakers and advocates can, of course, add other provisions to this template. For example, the Colorado Voting Rights Act has provisions that protect LGBTQ voters. But all of the provisions they really come from the Federal Voting Rights Act. They're intended to strengthen, streamline, and preserve vital protections and make those protections easier to enforce and administer. And so in this webinar, we're actually going to talk in depth about 4 of these provisions. The prohibition on voter suppression and vote dilution, preclearance, protections for limited English proficient voters and voters with disabilities, and enforcement. And I get to start us off. So one of the main things that the Federal Voting Rights Act does is prohibits state and local governments from imposing racially discriminatory election policies. Sometimes those policies result in voter suppression, meaning that they make it difficult for voters to actually cast their ballots. An example of that would be a county choosing to close a large number of polling places in a predominantly Black community. Other times, these policies result in vote dilution, meaning that they reduce the power of certain votes. And an example of that would gerrymanders the community so they can't elect candidates of their choice. The Federal Voting Rights Act gave voters the right to take state and local governments to court to challenge both types of policies. And this is such a powerful tool because it actually rights. But as you've heard from many of the previous speakers, over the years, the Federal Voting Rights Act has been weakened. I believe Janai called it a shredded shield, which is a phrase that's going to stick with me for a while. And one of the reasons for that is that federal courts have spent years creating a body of case law that makes it extremely difficult for plaintiffs to win their cases. And there's a lot of uncertainty, of course, about what will happen to the federal VRA in the future. So the prohibitions against voter suppression and vote dilution that are written into are there to ensure that a state's voters will always have the right to challenge policies that result in voter suppression and vote dilution, whether in state court, no matter what happens on the federal level or what the Supreme Court does in the future. And they can bring these claims in state's attorney general, and the model state VRA also improves on the federal VRA in a few different ways. It undoes some of the really onerous burdens that federal courts put on plaintiffs and makes it easier for them to prove in state court that a map or a voting system is racially discriminatory. It also provides just a lot more clarity and guidance about the types of evidence that can be used to prove voter suppression and vote dilution. In the past few decades, we've seen every possible legal battle that can be fought over how to interpret various terms and aspects of the federal VRA. The model state VRA basically answers all of those questions in advance, which makes it easier for judges to apply and makes cases brought under it more predictable and less expensive and less time-consuming. And now I'm going to pass it along to my colleague Michael Pernick at LDF to talk about another core provision of the model bill, preclearance.
Thank you so much, Lotta. Good afternoon, everyone. My name is Michael Pernick. I'm a senior counsel at the Legal Defense Fund, and I've been working closely on the development and enactment of state VRAs for over 6 years. So it's genuinely exciting to be able to present the model bill today. And as Lotta said, I'm going to focus on one of its core components, preclearance. Now, as many of you know, preclearance under the Federal Voting Rights Act was long seen as the most effective protection against voting discrimination in our nation's history, the crown jewel of our civil rights infrastructure. Federal preclearance required jurisdictions with a history of voting discrimination to obtain approval before making changes that affected voting, to ensure that those changes didn't make protected class voters worse off. Now, this was an extraordinary policy innovation because it ensured that discrimination never took effect in the first place. Now, as others have talked about, federal preclearance was effectively dismantled in 2013 in Shelby County v. Holder, which invalidated the coverage formula that determined which localities would be covered. So preclearance itself was not struck down, the coverage formula was struck down, and without a coverage formula, we didn't have any functional federal preclearance. In her dissent in that opinion, Justice Ruth Bader Ginsburg famously warned that eliminating preclearance was like throwing away your umbrella in the middle of a rainstorm because you're not getting wet. And Justice Ginsburg turned out to be 100% correct. Immediately after Shelby County came down, there was a wave of voter suppression and anti-voter legislation that was introduced and enacted across the country. We saw discriminatory voting changes happening across the country, polling place closures in unbelievable numbers, especially in communities that have long suffered from voting discrimination. So it really became clear how powerful and impactful this tool had been once we saw the effects when it was eliminated in Shelby County. Now, state VRAs and the model bill respond directly to that threat by adapting the core preclearance concept, this idea that we can stop discriminatory changes before they occur, and taking this concept to the state level. Under the model bill, localities with a history of racial discrimination in voting, such as past voting rights violations or severe racial disparities in voter registration or voter turnout, would be required to get pre-approval from a state agency before implementing certain voting changes. And what sort of voting changes are we talking about? Pretty much what you would expect. Things like new local redistricting plans or a decision to move the location or close a polling place would all have to go through this preclearance procedure. Now, each state is different, and leaders in each state would need to carefully tailor the program to the needs in that state to make sure that we're covering, that we have a formula, a framework that covers the right jurisdictions that actually need to be covered, to make sure that we have the right state agency that's administering the program. In some states, it might be an attorney general. In some states, it might be a secretary of state. In some states, it might make more sense to establish an independent commission. But regardless of the details and the specifics, the ultimate policy idea is the same. This is a policy innovation that's powerful because it's preventative. It efficiently protects voters because before harm occurs, and it avoids the need for costly, time-consuming litigation after the fact. There's that famous expression, an ounce of prevention is worth a pound of cure. Now, 2 states have adopted preclearance so far, New York and Connecticut, and we've seen the impact of New York's preclearance program since it's been in effect now for over a year. The AG's office has successfully administered the program, covering a few dozen jurisdictions across the state. And the New York AG even has an online portal that you can go to where you can see submissions, see the status, and submit public comment. So importantly, this is not theoretical. State level preclearance is already working, and it brings this important historical policy innovation into the state level. With that, I'll pass it over to Patrick to continue the presentation.
Thank you, Michael, and hello again, everybody. I'll be speaking now, along with my friends at LatinoJustice, who I will turn the mic over to shortly, about another really important part of the model bill, and that's protections for those who are limited English proficiency and have disabilities, essentially the language access protection. And we will be talking about how the model bill's provisions shore up and exceed and improve upon the existing federal protections that are out there. And, you know, as part of this project's vision of promoting a multiracial and thus often multilingual democracy, language access for voters in the form of translated voting materials and election information that is available to voters throughout the entire process of voting, from registration all the way to the casting of a ballot, is a crucial part of this effort. While some protections do exist for limited English proficient voters under federal law, the model bill expands on those to be more inclusive to language minority groups not protected by federal law, such as the folks who speak Arabic or languages of the African diaspora. It's more comprehensive in the language access that is being provided and more targeted to make sure that different communities get the type of access they need, all without creating unmanageable or unaffordable burdens on election officials. This is done, in part, by introducing a tiered system of language access coverage, customizable to the size and characteristics of the language minority communities in a given state. It's more flexible and responsive than current federal standards, which again exclude folks based on the languages they speak or the nature of their communities. Larger language minority communities will get access to a more effective array of services than is stipulated under federal law, while smaller but developing communities who would be shut out completely from federal protections are able to get access to the translations and in-language assistance they need to continue building power through the polls. An additional innovation of the model bill is a formal petition process, allowing communities to demonstrate their need for additional specific language services. And we use that word specific a lot because that's one of the big factors here of the language access provision of the model bill. Is that regardless of your tier status, you have the ability to demonstrate a need and showcase that there's something that your language minority community needs in order to be able to vote effectively. To provide effective and efficient access to voters across the panoply of America's languages, there can't be a one-size-fits-all approach. The model bill gives states a comprehensive tool for providing language services adaptable to the needs of, and there's that word again, specific language communities that it will serve. And now I'll turn it over to my colleagues at LatinoJustice, who will go into detail on more of the model bill's language access provisions, starting with Isabel Mulbauer.
Thank you, Patrick. So the bill also creates a public review process for language access, which means that covered subdivisions have to make their translated materials and their language access plans available for public input. This matters because federal law does not adequately create meaningful oversight of the quality of translated materials and services. This provision builds a feedback loop between communities and election officials so issues can be continually identified and corrected. The bill also codifies Section 208 protections in state law. And as you may know, Section 208 guarantees that voters who need assistance due to disability or limited English proficiency can bring a person of their choice into the voting booth to assist them. But in practice, we regularly see poll worker confusion and improper denial, and even attempts by jurisdictions to place limits on how it can be used. By placing this protection in state law, the bill removes ambiguity and gives voters and advocates a clearer tool for enforcement. Finally, the bill also incorporates protections analogous to Section 4E under the federal VRA, making explicit that English proficiency cannot be used as a barrier to voting for Puerto Rican voters. Including this protection in state law is particularly important in places where federal case law has weakened how 4E is applied, because it gives advocates a stronger and more direct basis for protection. And now I'll turn it over to my colleague Miranda Galindo, who will walk us through some of the enforcement mechanisms in this model bill.
Thank you. It's my pleasure to now talk to you about the teeth of the bill. What do you do once a violation has occurred? If you have all of these beautiful protections, but no way to enforce them, they're not meaningful. And I think that as a baseline, we can all agree that the strength of protections against vote dilution and vote denial should not depend on the politics of who is in office. Unfortunately, today, we live in a country where some states like South Dakota are arguing that only the government should be in the position of being able to enforce the protections of the Federal Voting Rights Act. And that's why it's very important that in our model bill, we are very explicit that everyday people and organizations have a private right of action to enforce these protections. I also want to talk about what happens after a violation has occurred. What are the remedies that our model bill champions? This model bill ushers in a broad range of remedies. For example, while we all may be familiar with the redrawing of district lines in the event of vote dilution, there are other remedies like alternative election systems. And here you can think about things like proportional representation, open primaries, and fusion voting. An example of that is the Workers' Family Party in New York. And these alternative election systems and other remedies like that are not currently favored as remedies by courts, despite their potential to reduce racial disparities. And our model bill is paving the way for the future of our multiracial democracy. Next slide, please. We're now going to transition into the practical part of our program. How can you all plug in and use this as a tool? Next slide, please. This is a resource for every stage of your campaign. Let's start off with states where a state voting rights act is not a politically viable solution in the short term. I live in Florida, and Florida's State Voting Rights Act bill has been an organizing resource to raise public awareness and build coalitions to further a long-term campaign for democratic reform. This has been a beacon of hope for people like me who feel very beaten down by the anti-democratic onslaught from our current legislature. In contrast, this is also a resource for states that already have state voting rights acts. Let's look at New York. Advocates and legislators may look to our model bill to mine the gold standards that we have presented here when contemplating what amendments may be appropriate for New Yorkers in their John Lewis New York Voting Rights Act. It is similarly a guide for litigators interpreting existing State Voting Rights Act provisions. AALDEF and LatinoJustice recently road tested the New York Voting Rights Act, winning the first settlement under vote dilution. And that experience proved to us the importance and effectiveness of the robust standards in the State Voting Rights Act, and also the value of thoughtful guidance on implementation. Now we're in the public education phase of that settlement agreement. And in our campaign in Nassau County, we have this model bill as a piece of literature that really builds our capacity to increase the public awareness and appreciation for state voting rights acts generally. I'd now like to pass the baton to our esteemed colleague at LDF, Amani Brooks.
Thank you. So the moment you've been waiting for, how do you access the model bill? If you scan this QR code, you will go to the model bill landing page. I believe the link will be posted in the chat shortly. On that page, you can request the full model state VRA text. There are resources regarding learning more about the provisions as well, and also about the movement at large. And we ask that you download, disseminate, and connect with the National State VRA network going forward. At the bottom of the toolkit page, there is a contact form to get connected. Next slide, please. What the model VRA unlocks. This fully fleshed out model state VRA is a positive vision for protecting state rights at the state, voting rights at the state level. This shared framework is going to ensure that every state can benefit from the experience and best thinking of states that have gone before. We're no longer reinventing the wheel. And we're excited about this platform to build upon for public education and power building in communities where voting rights are constantly under attack. And now I will pass it over to Michael to start the audience Q&A and close us up.
Excellent. Thank you so much, Amani, and thank you so much to all of my colleagues who gave such wonderful presentations. So we've received a lot of questions in advance and quite a few questions in the chat so far, which really speaks to the urgency of this moment and the seriousness with which people are already engaging with this model bill. So we don't have time for everything, but given the number of questions, I'm going to do my best to group related questions and try and surface some themes that we've been hearing most often, to try and give you clear, practical answers rather than rushing through a long laundry list of questions that we wouldn't have time for. And we'll continue to take questions in real time through the Zoom Q&A function, so folks can feel free to drop questions down there. We'll get to as many as we can. Some of them I'll try to address myself, and for others, I certainly plan to enlist my fellow presenters. So let's get started. We've received quite a few questions about Calais. What implications will Calais have on state VRAs? How should we be thinking about state VRAs in light of the upcoming Calais opinion? How will state VRAs stand if we get an adverse opinion in Calais? So I'm happy to take a crack at these important questions. So at the outset, there are two distinct narratives around the implications of Calais on state VRAs. On the one hand, Calais has generated extraordinary momentum in support of state VRAs across the country. Policymakers and advocates recognize that the federal VRA is under unprecedented threat, and Congress is unwilling to act. There is legislation in Congress, but it just isn't going to move under this Congress. So as a result of the confluence of the litigation and policymaking at the federal level, there's been an overwhelming demand for a strong, workable model bill to support legislative efforts at the state level. And there's deep interest in state VRAs from leaders across the country, including some of the states that we presented earlier, as well as other states that haven't yet had these efforts been made public. At the same time as we've been seeing all of this momentum, there have also been serious questions raised about the constitutional implications for state VRAs if Calais comes down in certain ways. And our view at a high level is that the risk of Calais is no reason to stop this important work. In fact, it's all the more reason to move this work forward quickly. So here's the key point. Regardless of how the Supreme Court ultimately decides Calais, it is unlikely to have any direct implications on state VRAs. And the indirect implications would be contained and would likely be somewhat minimal. Now, even in the worst case scenario, if Calais is viewed as a signal for how courts might ultimately evaluate certain provisions in state VRA litigation, it would only implicate one portion of the bill, vote dilution. It doesn't implicate voter suppression, doesn't implicate pre-clearance, doesn't implicate language access, doesn't implicate any of the other core provisions of state VRAs. And even with respect to vote dilution, the potential implications are somewhat limited. So in Calais, as I'm sure many folks know, the court is most focused on the constitutionality of race-conscious redistricting plans as remedies under Section 2 of the federal VRA. Now, even if the constitutional constraints of Section 2 remedies are constrained and courts apply those same constraints to dilution claims under state VRAs would still be operable. You would still be able to get relief. It would just be subject to the same constitutional limitations that we see under Section 2. And what makes state VRAs different from the federal VRA is that it doesn't necessarily, well, even neither the state VRAs nor the federal VRA necessarily require race-conscious remedies, but state VRAs explicitly authorize a list of race-neutral remedies. Things like proportional ranked choice voting or cumulative voting or limited voting, proportional remedies that don't require a map maker to draw maps using race in order to ensure compliance. And that gives us a level of comfort moving forward with this work and moving forward with the dilution provisions in particular, even though Calais is looming. So for all these reasons, Calais should not deter states from acting. To the contrary, the legal landscape and Calais opinion underscores the urgency and the need for leadership and action at the state level. So the next question that we received in a variety of forms, folks have asked about the common political barriers that state VRAs have had to overcome in order to get passed. And I'll turn it back to our colleague Patrick to talk a little bit about our experiences on that point.
Yeah, thanks everyone for the questions on this. And unsurprising that there would be, because any sort of legislative action like this is going to run into some barriers, no matter how perfect all the bill text might be. As I say, it was one of the co-drafters. I think one of the common barriers that we run into, of course, are concerns about cost and administrability. Particularly from election clerks, whether it's over language access or pre-clearance, or several other provisions in the bill. And, I think there's understandable concerns about unfunded mandates and things like that. So I think that's something that, as an advocate, you want to be ready to meet head on, by doing a little bit of research to make sure that you are able to head off any talking points about inflated costs, or about the massive administrative burden that this might create. You can look at states like New York that have been able to run effective pre-clearance and language access programs already without the sky falling. But I think the other part of this is, as much as you can, be proactive and try to reach out to these clerks in advance to try to hear them out, to get their understanding, because they can be a powerful ally, or at the very least a powerful non-enemy in some of these bill efforts. If you can hear out some of their concerns, try to explain why the provisions of the model bill are not overly burdensome and costly. And I would say the other one that I will flag here quickly, I know we have to go, is just sort of the why do we need this in insert blue state here? Which I think, depending on what state you're going to bring it in, if it's maybe somewhere in the Northeast or something, you might get that complaint. And I think to overcome that, you have to sort of highlight the local nature of what's going on, and how most of these state provisions are applying to local governments, where there are cities, towns, places that still exemplify discrimination, and there are still all these factors. And some of the model bill has lists of some of the factors you need to look at in order to qualify for pre-clearance, or some of the language access issues that are very prevalent where there's developing communities in otherwise blue states. So I think those are two things that I'll flag for folks as they take this model bill and run with it, to want to prepare for.
Thank you so much for that, Patrick. And I'll add one other thought for folks' consideration. So we find in a lot of states, we encounter questions about the complexity of the bill, because it is a long bill and it has a lot of provisions, it has a lot of sections. And folks raise questions about why we have to go into such detail about legal standards and about the different types of provisions and types of rules that we're putting in. And relatedly, there are questions about certain terms and concepts, things like racial vote dilution or racially polarized voting. And what are these foreign terms that certain state legislators and leaders and stakeholders may understandably be unfamiliar with? So any state VRA campaign requires tremendous education of legislators, of stakeholders, of policymakers, so folks understand what the federal VRA did, understand what are the protections that are under threat or that have already been lost. And that also helps make state VRAs less threatening, because at its core, state VRAs aren't trying to do something that's wholly new. We're building on decades and decades and decades of experience with the federal VRA. So one thing that we've done to really overcome those questions is deep education of stakeholders in ways that might not be necessary in other legislative campaigns. So next, we've gotten a lot of questions about the prospect and the strategy around introducing and advancing state VRAs in hostile states where leadership would be hostile to pro-voter voting rights protections. So I'll turn it back to Miranda, who already spoke to this a little bit in the presentation, but I'll turn it back to Miranda to provide a bit more detail on how we think about that.
Sure. I mean, that question makes me sad in a way, because fighting racial discrimination, even in the voting context, is a nonpartisan issue. The civil rights movement, including all of our organizations, have fought to protect the rights of Black and Brown voters on both sides of the aisle. And maybe that's why the Federal Voting Rights Act was a bipartisan achievement. And I am heartened that in some states that continues to be the case, for example, in Connecticut. But I do live in the real world. And let's talk about that hard question, as sad as it may make me. So despite the fact that passage of a state voting rights act is not politically viable in the short term, a number of states that are in this reality, Florida, Texas, Alabama, and Mississippi, have introduced these bills. And this is very important because these are some of the states where state voting rights acts are the most needed. But it's also important because it builds a future where passage may be possible. So going first to the short term, in this period before it is politically viable, every time that there are instances of discrimination, advocates can point to the introduced bill and explain that if this bill were to pass, this either wouldn't be happening or there would be a clear-cut pathway to fight it and overcome it. I don't know about you, but I am very refreshed by the idea of having an affirmative vision of something to fight for and not constantly be putting all of my energy into drinking out of the fire hose and responding to attacks on our democracy. And having a bill introduced, even in my state of Florida, has been really heartening. And I hope that this model bill helps everybody in other states in this situation articulate their affirmative vision of how the right to vote in your state should be protected. So a little bit more on Florida. Every member of the Florida Minority Conference has co-sponsored the legislation. And in a very creative turn of events, the text of the Florida Voting Rights Act helped defeat a bad voting rights bill in the form of a hostile strike all amendment. Michael, I can either turn it back to you, or I know other colleagues here may have more to say on their experience in similar political contexts.
Yeah, no, that's great, Miranda. And I'll just give a shout out to the advocates and leaders in Florida, some of whom I know are on this call, who really did a wonderful job and at taking this important legislation and using it as a tool for energizing, for engagement, for leadership in the state. So thank you, Miranda, for lifting that up, and I'll just second the wonderful work in Florida. So the next question, we only have a few minutes left, but the next question. To what extent do state VRAs go beyond the federal VRA with respect to vote dilution? And I already referenced one important way a few minutes ago. Many state VRAs explicitly authorize alternative methods of election as remedies, including proportional ranked choice voting and other proportional and semi-proportional systems. And that, of course, is an important part of our model bill as well, and really important as we move forward, regardless of what happens in Calais. But I'll turn it over to Lata to speak in a little bit more detail on this important question.
Thanks, Michael. And I would say that the state VRAs just can make parts of bringing a vote dilution lawsuit less burdensome than they are under the federal VRA. For example, under the federal VRA, proving vote dilution requires presenting evidence on the totality of circumstances and establishing that racially polarized voting exists in your jurisdiction. That means that minority voters are less likely to elect candidates of their choice than other voters. But in places with a long history of discrimination, minority preferred candidates might not run for office at all. So that sets up a situation where it's impossible to prove vote dilution in the places where it's most severe. And that's why state VRAs in our model bill gives plaintiffs more options. They can present evidence of racially polarized voting, or they can prove vote dilution under the totality of the circumstances, which means introducing evidence of things like the history of discrimination in the jurisdiction, or disparities in voter participation, lack of responsiveness of election officials, and all of that. And there's a lot of other relevant factors there, but it gives plaintiffs that flexibility. And you brought up that under state VRA, you can have remedies that are alternative methods of election. And part of that is because under the federal VRA, just as an initial matter, if a community is challenging vote dilution, they have to show that they're large enough and compact enough to make up the majority of the district, because the only real remedy there is drawing a district with where the community can be the majority. But just opening it up to different remedies also means that that's not a requirement. It's not that under the federal VRA, only residentially segregated communities can bring vote dilution claims. Then state VRAs recognize that you can still have your voting power diluted even if you're not a residentially segregated community. So those are two pretty important things, I think, that go beyond the federal VRA there.
Thanks so much, Lata. We have time for one more question. We received quite a few questions about next steps. How do we build a strong community of advocates? What resources are available to support this important effort? So I'll turn it back to Amani, who already touched on this a little bit, to provide more detail for folks.
Sure. So I want to underscore first that this work is driven by local organizing. We would not be able to do this without our state partners. So we encourage folks to connect with in-state partners, which vary from state to state, but might include a common cause or League of Women Voters. And then to support the various state coalitions, we are working to build this national network of folks doing the work. And that being said, I'll go into a few ways to get plugged in. So if you want to be connected to one of the orgs here or in-state org, please fill out the contact form at the bottom of the toolkit or reach out to state VRA at naacpldef.org and we will get back to you. There are also monthly calls that bring together those interested in state VRAs and features deep dive policy presentations and campaign updates. So you can also reach out to that same email, I'll put it in the chat, with a request to be added to calendar invites and listservs. And in addition to the State VRA Toolkit, as I mentioned in the presentation, many of the co-authors have their own resources on their websites, and I'll drop some of those links into the chat. So please visit them to learn more about state VRAs as they are introduced, are passed, and enforced. So I'll turn it back to Michael to wrap us up.
Thank you so much, Amani, and thank you so much to everybody who submitted questions. I know that there were a number of questions we didn't get to today, but we'll continue to stay in conversation as this moves forward. Now, what I hope came through in this conversation is that state VRAs are not theoretical. They are practical, necessary tools, and they're very much within reach. So what matters now is leadership and follow through. And our hope is that this model bill will equip policymakers and advocates with the tools that they need to move this work forward. So with that, I will turn it back to Demetria to close us out. Thank you.
Wow. I mean, just wow, right? Listen, I want to close by thanking our presenters and all of you for being here with us today. And most of all, I'd like to thank the Asian American Legal Defense and Educational Fund, the Campaign Legal Center, the Election Law Clinic of Harvard Law School, LatinoJustice, just for being amazing partners on this project and for getting the work with us done more broadly. So if you took anything away, I hope you took away the sections about how to get plugged in. Now, as a reminder, you can access the model bill and related materials at the link in the chat, right? Imani told you about that, naacpldef.org/State Voting Rights Act Toolkit, all right? Access that. Folks, this is a critical time for voting rights in America, and state VRAs are a powerful and practical tool for a popular solution that we're trying to address. This is discrimination is this issue we're trying to address and solve for that head on. Now, I know that many of you on this call are already involved with the expanding movement to enact state VRAs, and I certainly hope others will join you. So we have a whole bunch of work to do together, folks, and we hope today's model legislation takes the growing momentum around state VRAs to the next level. So thanks for being here and have a great and safe weekend.